Hello, viewers. My profound greetings to you all. Today, we'll be looking at an important element in the law of contract or in the formation of a contract. Today, we'll be discussing the element of consideration. The objective of this lesson is to look at the definition of consideration and the enforceability and unenforceability of certain promises. Now, to the definition. In inquiry against Misa, a consideration was loosely defined as a right, benefit, profits, or interest accrued by one party and/or a loss, detriment, or forbearance undertaken by another. In other words, consideration is a promise or an act given in exchange for something of value in the eyes of the law. So, for example, if Usman promised his son Ibrahim his house, and Ibrahim in turn offered 1 million loans for maintenance fee, the question that this raises is whether Ibrahim can enforce the promise by his father. The answer to that question is yes. Ibrahim's promise to pay 1 million loans to keep the house in good repair was a good consideration to support or enforce his father's promise to convey the house. Now, in the example given above, Usman's promise to his son was given in exchange for 1 million loans by Ibrahim. The exchange is apparently a benefit to his father, Usman, because the house will now be in good shape. Equally so, Ibrahim has suffered a detriment or undertaken a loss by giving 1 million loans as a maintenance fee for the house. Now, another essential feature about consideration is that it need not be adequate but must be sufficient. Now, in the law of contract, sufficiency means of some value in the eyes of the law. Adequate means of a value equal to the other party's consideration. So, for example, suppose Ibrahim's father decides to go back on his words and argue that Ibrahim's money is too small considering how big the house is. In other words, the money is inadequate. Implicitly, he is suggesting that the 1 million loans given by Ibrahim is inadequate to support his promise to convey the house to Ibrahim. It is undeniable that the money might be too small. Nonetheless, Ibrahim, according to classic contract law principle, will still be able to enforce the promise because the 1 million loans is of some value in the eyes of the law. Now, the courts have been reluctant to impose anything on the terms of the contract between parties because contractual obligations are independently assumed by the parties during the bargaining process. And so for that reason, the courts are very reluctant to impose anything on the terms of the contract. So if you give even a 1,000 loans for a car, that is sufficient in the eyes of the law because it has some value in the eyes of the law. Now in Chapel, the court held that performance of a trivial act which has been requested by the other party can be a good consideration. Performance is likely to be a benefit to the person who requested it and a detriment to the person who performs it. Now, this case also illustrates another point aside from the fact that small acts or amounts are sufficient consideration because they have some value in the eyes of the law. That consideration need not only be in the form of money. Even performance of an act can be a good consideration to support a promise. So now another essential element as well has to do with promising to perform an existing duty imposed by law and a contractual obligation owed to the promisor, whether such promise is a good consideration to enforce a promise made by another party. Now, a duty imposed by law, it is not a good consideration to perform a duty imposed by law to enforce a promise. So, for example, A policeman who is under a statutory duty to protect lives and properties cannot enforce a promise by a citizen to apprehend a thief after an alleged robbery. So even if Abu offers to pay him, the policeman, 100,000 yuans to apprehend the thief, the policeman cannot enforce that promise since he is under a duty imposed by law to do so, to protect life and property, to apprehend a thief. One way to sidestep the general rule or an exception to that rule would be, now if a policeman went beyond the scope of his normal duty, he may have provided a good consideration to support or enforce a promise made by an ordinary citizen. Now, this was illustrated in the case of Ward against Biam. Now, the issue in this case was whether a mother who was under a statutory duty to care for her child could enforce her ex-husband's promise to pay an additional sum if the child is well taken care of. The court noted that although the mother was under a statutory duty imposed by law to look after her child, she had gone beyond the statutory duty by complying with her ex-husband's request, and this was sufficient consideration for her ex-husband's promise to pay more. And now to the second aspect, duty imposed by a contract owed to the promisor. Performance of an existing contractual duty is not sufficient consideration to enforce a further promise to pay more. Now, this principle was illustrated in the case of Silk against Myrick. The issue in this case was whether a further promise by the captain to pay more to the crewmen after two men deserted the ship amidst an existing contractual agreement between the parties that was already formed earlier before sailing could be enforceable. The court noted that the crewmen were bound by the original terms of the contract that was already reached before they went on board, before they sailed for the sea, and that they had done no more than they were already contractually bound to do. This rule also has an exception or a way to sidestep the general rule. Now, if it can be shown that the promisor enjoyed a factual benefit after promising to pay more, then the promisee can enforce the promise. This principle emanated from the case of William against Rofe Bros Limited. A factual benefit can only be determined depending on the prevailing circumstance. Thank you for listening. Next, we'll be looking at past consideration, alteration to promises to pay less, and the equitable doctrine of promissory estoppel. Don't forget to subscribe, like, and comment.